of the Tierra Jones case served in discovery. We can't hear you.
They can't hear you.
Your Honor, there were portions of the Tierra Jones case served in discovery. The pictures were served on May 22nd, 2023. The recordings were served in discovery 12. I'm trying to find the exact date of when. And so the pictures were served in May 22nd, 2023. And there were some initial reports served on that same date, not the lead detective's report, but like,
Okay, so,
all reports.
great. I was actually asking about the letters.
So
That
the
were
letters-
things that were brought up this morning.
So it does not appear that either letter was served.
All right, then y'all
Oops.
don't intend to
Out.
use those, right?
We don't have to use it.
Okay.
Big L. Wow.
So I'm just trying to sort everything out before we have a jury in here. I'm trying to understand, my client gave a statement as a victim. I don't know if the state, I understand the state's not intending to use the letters. Is the state intending to use my client's statements at all?
No, I think Mr. Sharp asked me that yesterday. I advised that we will not be using, we don't intend to play his statement. We do intend to ask the detective whether or not Mr. Stillwell made a statement, how many statements he made.
They're going to read the
Two at the
transcript.
hospital, one 3 days later, one about a month and a half later. In the second interview, he gave more details about the incident in which he was a victim. And my intentions, so I can complete the story and make sure that the jury understands that he subsequently recanted that statement. But that is what's in that letter that I provided to Mr. Sharp last night. That
Last
second
night.
letter, he recants everything he told the
The
police.
second letter that Mr. Shard has never until last night gotten notice of.
Sanction.
Correct. And so we cannot put that in, but I would thought that Mr. Sharp would want the jury to know that his client took that back or took his statement back. But if he doesn't,
You should have just
we
given
have
him
no
everything.
issue not talking about the second letter.
So my understanding of the rules of evidence, first of all, I agree, and I appreciate that the letter's not coming in because it was not provided in discovery. But my understanding of the rules of evidence, I don't know why, these are no ways admissions. These are statements my client made about, I'm going to say wholly unrelated incident. I know it's part of this story, but he was a victim in a case. So from my perspective, this is all hearsay. And Your Honor, just to give you a little bit, there's parts in this statement where my client is saying, I didn't see anything. I don't know who did this.
Right.
The investigators are sitting in the room saying, well, give us 3 names, give us 3 names. And he's like, I didn't see it, give us 3 names. So, I mean, that's the type of police work that quite honestly leads to, in the 3 names that were eventually given, weren't the 3, I think one of the 3 was the same people charged. 2 of the 3, I don't believe were ever charged. So it's like, you know, they were just like, give us 3 names. And then they had him look at photo lineups, and he didn't even, and when he was looking at the photo lineups, he didn't even say, oh, this is the person that did it. He's just like, yo, that's Shelkel, that's so-and-so. So I don't even think it was a recantation, but I don't want any of my client's statements, the contents of which, and I understand the state has told me they don't plan on playing it, but I don't want them to ask about the contents of it.
So to be clear, Your Honor, because I think some things are getting conflated. In the first interview that Mr. Stillwell gave at the hospital, he said he didn't see anything. Second interview, he was asked to give names. He did not give any names. He didn't say anything. Again, he gave no names in the second interview. It wasn't until November 2nd when Mr. Stillwell asked on his own to speak to the investigators. He told the investigators everything that happened, and then he provided names at that juncture. There was no pressure of just give me 3 names. None of that occurred in the third interview. The state believes that that is still a party opponent statement, that he is still a party opponent in this case. This is a statement that he made to law enforcement regarding an incident that occurred to him as a victim. So, Your Honor, we still believe under the rules of evidence, it would come in as a party opponent statement. That is what we are operating under. It doesn't have to be inconsistent. It is his statement that he has previously given to law enforcement about something which he was a victim. So that is the evidentiary rule that we intend to introduce this statement under. And again, asking questions about the statement, not playing the statement.
And then do you intend to do something about him allegedly later having said what I told you in November? I no longer stand by that now, or whatever he might have said.
The state intended to ask not this detective, because this detective was unaware of the recanting.
I don't know
However,
what you mean by this
the
detective.
detective investigator Griffin, who was the lead detective on the homicide, he was unaware of it. However, investigator Dennis was aware that his client, that Mr. Stillwell recanted. And so it was my intention to ask about whether or not Mr. Stillwell took that statement back subsequently. I did intend to ask that question.
Okay, and you're saying that this is all, I guess, a statement or an admission by a party opponent because you're offering it against Mr. Stillwell? And how is it against Mr. Stillwell?
You're right. When Mr. Stillwell was shot at, this was all a part of this gang war that we have been discussing.
Okay, I mean, do you have any evidence of that?
The individuals who were charged are members of the opposition gang.
And
mean
when did it
anything.
occur?
This occurred on the early morning hours of September 26, 2015.
Has anybody been convicted?
Yes,
Okay, so members of an opposing gang were convicted of this shooting?
yes, one individual I believe pled earlier this year.
Okay, and did Mr. Stillwell, when he gave the November statement, identify any of those people?
He did.
How many?
He identified 3, and I need to confirm, I know one person, Mr. Hardy, I believe is the one who took the plea earlier this year, or last year.
And are those 3 people the people that ended up charged?
I know Mr. Hardy was one. I need to see if, I know Mr. Hardy, Mr. Watts, and there's a third person. Mr. Watts, after further investigation, the case was dismissed against him. And then the second individual, I just need to confirm whether or not he was ultimately charged and the case was resolved. But out of the 3 people he identified, Mr. Hardy has taken a plea. The second individual, I think, is Mr. Ward. I have to confirm whether or not he took a plea. And then Mr. Watts was not, he later, after Mr. Sprinkle did further investigation, Mr. Watts was not charged with ultimately was not charged with the homicide.
So
Your
when
Honor-
he recanted,
So
what did he say?
I'm sorry.
When he recanted, what did he say?
Let me pull up the letter. He said he was pressured and that everyone that he said did it didn't do it. He didn't know who did it. And the letter came after members of the opposition gang, I guess, received a discovery package. And in the lead detective's report, the lead detective said that Mr. Stillwell made identifications. And so they posted it all over social media. And so it was after that posting that Mr. Stillwell recanted. And also my understanding is there may have been some altercations while Mr. Stillwell was in the Fulton County Jail that also led to Mr. Stillwell recanting that
Okay,
statement.
and 2 of the 3 people about whom he recanted ended up with their cases either dismissed or not pursued?
One definitely was not pursued. I am trying to confirm the second individual.
Just to give you a little context, Your Honor, this murder of Tierra Jones happened at about 11:45 p.m. on a dark road, and a car sped up behind the car, and started shooting. I don't know. I mean, this case would have been a defense attorney's dream to defend the Tierra Jones sad case, but because there would be no indication that Mr. Still would have seen anything. It was after the police were saying, "Give us 3 names, give us 3 names, give us 3 names." Then he gives 3 names, and
Well,
I think
except a whole month went by.
I understand, and then I think one or maybe 2 of them were charged, but I think it was only one of them. I think it was only Bobby Hardy. I believe it was only Bobby Hardy that was charged. So, I don't see the relevance. Ultimately, I mean, I have a lot of arguments, but ultimately, I don't see the relevance of any of this. My client being in the car, I see that as relevant, but I don't see the relevance of my client's statements to the police regarding this matter.
It's relevant because he identified members of the opposition gang who did the crime. And so that is why it is
I don't know
relevant.
if you can say the who did the crime part, since even y'all seem to have decided that some of them didn't in fact do the crime.
He ID'd 3 so what's
He
relevant.
ID'd 3 members of an opposite gang, and then he later said, no, I take that back.
Right, and he did that after the opposite gang posted on social media. So all of that, when we're talking about gang evidence and recanting and snitching, all of that is relevant for the jury when a young woman is murdered innocently as an innocent bystander, and there's more evidence than just a car pulling up on the side of a dark road. It starts at a gas station where Mr. Stillwell tells the police he sees some of these individuals at the gas station. There's surveillance video. So there's a number of other pieces to it. To truncate it, we were solely going to talk about Mr. Stillwell, what he told the police that he saw and what he observed, and the fact that the individuals who he identified were members of the opposite gang, that there were individuals arrested. There would be subsequent evidence that would come in that.
That all doesn't matter.
And I don't know
it
if that part is
was
relevant, of
dropped.
who actually pled or not, but the fact of the matter is, these people, it's who he identified, and that was the opposition gang. And that is relevant in this grand scheme of talking about the back and forth that was happening between January and ultimately October, once most of these defendants that we've been discussing were arrested in 2015.
Well, I think we need to be careful about who when we say who Mr. Stillwell said did this as well. And I reviewed the transcripts last night. I've reviewed the videos several times. But my understanding of what happened during the third interview, where identifications were made, was that Mr. Stillwell spoke about seeing Mr. Hardy in the parking lot outside JJ's Chicken. He said he saw him there. And so they say, okay, we have some, and that makes sense to the detectives. Oh, Mr. Hardy, who they're calling him Smoke, I think, is at JJ's Chicken right before the car gets shot up. That makes sense to them. So they say, we have some we have some lineups we'd like to show you. And they read him the lineup admonition, and they show it to him, and he's like, that's Hardy. I think he calls him Smoke. And he identifies Shell Cal and Merle, I think is the other guy. Those other two individuals, to my recollection, and from the transcript that I read, he never says they did
These are the
anything.
people that shot me. He just
It
says,
says, I identified.
this is this person, this is this
Right.
person. What do you say to that?
The context of him telling the story of what happened. So that's something that they can cross about.
Do I
But
need to look at the interview and the letters?
no, the state did not intend, Your Honor, the state intended to ask Investigator Griffin, did you meet with him twice? Did he give you any information at those 2 times? Did he eventually meet with you again? Did he provide more information about it? Did he eventually tell you who he thought was involved? Did he make identifications? Who did he make identifications to? After that, did you
Okay,
learn?
but did he make identifications of, I know this person and this person, versus identifications of, these are the 3 people that shot me? That's 2 different things.
The context of the interview is,
So I need to look at it then.
We're about to turn this into a whole nother trial within a
Right.
trial.
we don't, Your Honor, literally, the state was going to have Investigator Griffin on the stand ideally for about 20 minutes, if that. So it's not turning in it's a 25-minute interview, Your Honor. I believe Investigator Griffin won't come until tomorrow.
She just snitched on herself. She said that they don't plan to play the interview or read the letters. She said they only plan to have him on the stand for 20 minutes. It's only a 25-minute interview. You are going to have the witness recite the important parts of the interview and the letters. That's why you keep saying you're not going to play. You're not going to read the letters. You're not going to introduce the actual best records. Because you're going to do what you've done with the other witnesses and just recite the parts of the transcript and the letter that you want to through the witness. She just self-snitched.
Tomorrow morning, so we can send the interview over to the court. You can review it. It's a 25-minute interview for the court to review. But that's not the
Point me
state.
to the portion that you maintain is him saying, these are the 3 people that did it, and then send me the letter that is the alleged recantation.
I can send you the recantation, but I
And
think
do
the
it
court.
quickly, because honestly, I don't want to spend the entirety of my evenings doing this case.
I don't think that the court can only look at the specific portion, because I think you need to see the entire video to understand how the identification came about. I don't think that the specific 5 minutes before or 5 minutes after will give the court that context that I think you will need when he does the identification, Your Honor. So that is the only reason why I'm suggesting that you watch the entirety of it, so you can understand the context surrounding the identification.
Okay, send it to me now so that our next break, I can start watching it,
I sure will.
along with the letter, both of them.
I will send you both.
And Your Honor, I know they said Investigator Griffin's not coming tomorrow. If we need to wait till tomorrow on this, there's one picture that was shared in the Dropbox. And just to remind the court, these were things that were never brought up to discuss the issues with previously.
This
This
is
Dropbox.
as to this same crime or
Yes.
incident?
Yes,
And, all right,
but we've
what-
never litigated it.
Somebody send me the picture.
Pictures as well, Your Honor.
And there's a picture of essentially a young lady, Miss Jones, and it's horrible.
Steele is ready.
And she's
Look at
After
Steele.
she's been shot.
bleeding from the face. She's halfway through a windshield, and her body appears to be burned. She's unrecognizable.
Okay.
And
And
that's,
it's
And the objection would be?
403, prejudicial. I know that my client is not accused of doing this to Ms.
Right.
Jones, but ultimately the
But,
state
yeah,
is
oh,
holding him responsible.
But for him being in the car, this wouldn't have happened to her.
Your Honor, the state did not intend to publish that picture. The state didn't intend to introduce it because unfortunately that is what happened. So the state did not intend to publish it. The state did intend to introduce it, but I will send the court the picture so you can see all of the pictures that the state
Well,
intended to.
if it's introduced, then it would be going back with the jury.
Yes, the jurors will see
Well-
it at some later time, but I didn't intend to
Let me
publish
see
it.
the picture. Somebody send it to me now. Is there some
That's all
other
they care
way
about.
to get in evidence that this woman was killed in the car crash that
This just means the jury's going to have
followed the shooting?
a
That's what happened,
tranche
right?
It's already in evidence, Your Honor.
That fact, right?
Yes, Detective Dennis testified to
I
that.
mean, I don't,
cumulative.
I'm going to sustain that objection to that picture.
All right.
Unnecessarily
So do you want to
gruesome.
send it or no?
No,
Okay.
don't worry about it.
Your Honor?
All right, so that takes care of the picture. Yes.
So, while you're,
You know, what I'm not appreciating is Mr. Williams has a right to then confront and cross-examine Mr. Shannon Jackson because this is confrontation clause. It is the police, it's a victim, from what I understand, identifying people in a criminal case. That's testimonial.
And
So-
what's the state's response to that?
Bill 0.
I mean, I guess if you are only having it elicited that he made a statement where he identified, how far is it going to go?
The state's intentions, was Mr. Stillwell a victim in a crime? Did you speak to him? Was he able to tell you who he believed to be involved in the incident? Who were those individuals? What occurred? I was going to ask him, what did he tell you happened? They were in a car, it
All
flipped
right, and
over.
so then what do you say about the confrontation clause issue?
Your Honor,
That's clearly testimonial, and it's hearsay. And it might be an admission by a party opponent. But that would be only as to him,
and we
really.
could do a limited instruction as to him. I mean, he's the victim in the case, so we have to, it's not a crime, it's not a part of the case, but he's the victim of a case. If it only has to be used against him to say that he was the victim, then we can have a limited instruction that,
Well, but you're not just using it to show that he was the victim.
Using to show
we
the
are
gang
showing that it was
rivalry.
a part of the gang war, but that he was the victim in this case. Earlier, a few weeks
Truth
ago,
of the
we
matter.
brought in the other shooting that involved Mr. Stillwell, where he was shot a few weeks prior to this at Glen Street.
And did any of his statements come in at that point?
No.
All right, well then, that's not really the comparable.
You mind if I can just have a moment to research that particular issue to see if he can come in some other way?
And just for completeness, I also include in the confrontation clause the quote recantation.
Yeah, I mean, that, which frankly is more than to just show he was a victim, because once you get into the, and then something got posted on social media, and then he went back and said something different, that further complicates things. By the way, it appears that Carter, Hardy, and Ward all pled to some charges in that case.
Those were the people that he named.
Those were not the people that he named.
No.
Okay.
He named Hardy. I'm not sure about Ward because it was a nickname, but he named 3 people, and one of them was Shell Kell, who's Kelvin Watts.
Okay.
He named Hardy and Merrill, who was Ward. The only person he did not name was Carter, and he named Watts. And like I said, after further investigation, Watts, I believe arrest warrants were taken off of Watts. That's what I need to confirm. But after the DA's office did further investigation, we did not indict Watts. We indicted Mr. Dominique Carter, also known as Stewie.
And y'all are saying that the only one that he said he thought had anything to do with this was Hardy? Not you, the state, you, the defense, sorry.
I understand the statement. He is saying that he saw Hardy talking to his girlfriend in the parking lot of JJ's Chicken shortly before they left.
So he never says that he thinks anybody did this shooting. He
Well,
just says, here are the circumstances leading up to it.
That's my understanding. And it would defy logic for him to have seen who the shooters were. It was a car sped up behind and started shooting in the windshield, and in his car, the car he was
Well,
in.
I mean, he could have said he was at the JJ's Chicken in a blue Buick, and then I saw a blue Buick drive up again, but I don't know if that's what happened or not.
He said the car was, he thought it was a newer model car because of the style of lights, is my recollection of what he said.
And does he tie a car he saw at the JJ's
I don't believe so.
Chicken with a?
I don't
No.
believe so.
Okay.
I think we have different understandings of the video, Your Honor. I just think once we do the research on the confrontation clause issue, then I believe we're sending over the interview to the court, or it's already been sent.
Okay.
Yeah, I believe all 3 were sent to you. All 3 were sent. It is just the 3rd video. It's both audio and video recorded using Evidence Reviewer.
Okay. And then the letter also needs to get sent. And this is a letter that y'all never got until yesterday.
Letter I never received till yesterday, and
Okay, so it seems problematic, even if you don't introduce the letter, to introduce essentially the contents of the letter.
My team is double checking something for me. Supplemental Discovery 11. I'm confirming whether or not this was the entire case file. So if you can give me one moment, I'm trying to confirm this is the entire case file.
Okay, well, are we in 2 minutes ready for the jury? Got your next witness lined up? Mr. Matthews, on a scheduling matter, actually 2 scheduling matters.
And guys, the reason that this issue isn't just squashed with the letter not coming in because the letter was turned over late last night is because Hilton's still trying to introduce the contents of the letter through the testimony of investigator Griffin when Griffin's on the stand, and possibly in part some of it with Dennis. So essentially, cool, we won't have to introduce the exhibit, but we'll just recite whatever's in the letter through the witness. So the jury will get to hear it either way, even if they don't get to see the actual letter. So, and that's been one big argument this whole way. I think Whitaker's sharp here with her pushback, and sometimes she's not. Sometimes she lets them talk, but I got a vibe there. She just wanted Hilton to stop arguing. And that's when Hilton kind of said, like, all right, just give us time to look at the case law, which they'll get to look at the case law, they'll get to make their record, and maybe that case law could be something compelling for Whitaker. Whitaker kind of like looked the other way, like she already knows there's not going to be case law that supports the state's position here. So we'll have to see, though. We'll have to see. And yes, very sharp with the confrontation clause.